Good morning or afternoon, depending on where you are sitting today, and thanks for joining this webinar. Today, we are going to talk about the Endangered Species Act, where our panelists will discuss what the latest changes are and how they might impact you or your projects. So we're going to take a moment here to have a little tech refresh. A couple of housekeeping items are that the webinar is being recorded and it will be available on the SWCA website. You should also receive an email with a link to the recording in the next few days. We also have the closed captioning available today. If you would like that, please click on Show Captions on your toolbar. Please note that all your microphones are disabled or are muted at this time, and chat has been disabled throughout the webinar. However, if you have questions, do please click on the Q&A button, and we will address as many questions as we can at the end of the webinar today. If we don't get to all of the answers today, we will follow up with you in an email and address all the questions that are relevant to today's webinar. So let me start off by saying hello. My name is Stephanie Graham. I will be moderating today's panel. I'm one of SWCA's senior ecologists. I have about approximately 20 years of experience working on natural resource topics in the federal, private, and nonprofit sectors. I'm super excited to have our two panelists today. Let me first introduce Amanda Glenn. Say hello, Amanda. Amanda is SWCA's Senior Technical Director for Biological Services and provides strategic guidance on permitting and compliance matters involving protected wildlife, plants, and habitats. She is currently managing a national practice and has more than 25 years of consulting experience with an emphasis on Endangered Species Act and how compliance with the Endangered Species Act influences other regulatory programs. Also joining us today, we're super excited to have Paul Weiland. Say hello, Paul. Paul is the assistant managing partner with Nassaman. He's a member of the firm's environment and land use practice group. Paul has also worked extensively on issues in federal wildlife law across the United States. He formerly worked at the U.S. Department of Justice, where he represented federal agencies in a number of high-profile cases under the Endangered Species Act, the National Environmental Policy Act, the Clean Water Act, and other environmental laws. Here's a quick rundown of today's agenda. Paul will be discussing the Maine Lobstermen case, which involves the precautionary principle. Amanda is going to hit on the regulatory updates on reasonable certainty, and then we will have some time to answer questions at the end of the presentation. Again, please use your Q&A if you have questions throughout the presentation. So let's start with a quick little background on the Endangered Species Act. The Endangered Species Act was enacted in 1973 with significant amendments in 1978, 1979, and 1982. It is administered by NMFS, also known as the National Marine Fisheries Service, and USFWS, also known as the U.S. Fish and Wildlife Service. The regulatory hammer in the Act is the prohibition on take of endangered species that can also be extended to threatened species. There are 18 sections of the Act, and the one that we are going to focus on today is Section 7, which is the part of the Act that has a federal nexus focusing on listed species. The key provisions of the Act are the process to determine whether to list a species as threatened or endangered, the process to designate critical habitat, the take prohibition, and the take authorization. There are other types of statuses of species within the United States, including those proposed for listing, 10J, which is an experimental population, and candidate species. But again, today we're going to focus on Section 7 of the Act. So a quick little visual to get ourselves oriented with the difference between laws and regulations and guidance and policy. So as a reminder, laws are passed by both branches of Congress and signed by the president. Laws establish requirements or prohibitions. Regulations are published by the executive branch agencies to clarify their interpretation of a law and how that law will be implemented. Regulations also state requirements or prohibitions. Some agencies also publish guidance and policy, such as mitigation policy that we're going to discuss a little bit later today. Guidance and other policy statements describe suggested or recommended actions. They do not provide mandatory requirements unless they are incorporated into regulation or mandated under terms and conditions of an agreement, such as a funding agreement. We also have additional state regulations and policy that can come into play. So today we're going to talk about how the courts interpret laws, regulations, and policy, and the feedback loop between the courts and the executive branch. And with that being said, I'm going to pass it to Paul with the first question of, can you provide a little background on the issues in MLA versus NMFS? And feel free to explain MLA and NMFS.
Thanks a lot, Stephanie. I think it's worth just kind of noting at the outset that there's a large and ever-expanding body of Endangered Species Act case law, and that this is in part because Congress has had difficulty finding common ground to amend the Act. To some degree, the executive branch and the courts have both had to fill that void. And so in this area in particular, you have a large body of law, and I'll be discussing just one of those cases, albeit I think we think it's a notable case. So the case is Maine Lobstermen Association versus National Marine Fisheries Service. And I should note at the outset that I am participating in the case representing the state of Maine, but nothing I'm saying today is in any way necessarily the view of the state of Maine or any of my other clients. This is my personal views, and my discussion of the case is based upon publicly available material on the case. The focus of the Maine Lobstermen Association case was on a rule promulgated by the National Marine Fisheries Service and a biological opinion generated by that agency. In addition to its Endangered Species Act responsibilities that Stephanie mentioned, the National Marine Fisheries Service also administers federal fisheries under several laws, including the Magnuson-Stevens Act and other federal laws. And in this case, the National Marine Fisheries Service was actually consulting with itself under Section 7 of the Endangered Species Act regarding the authorization of fisheries on the eastern seaboard of the United States, including the lobster fishery. And one of the species that was covered by the consultation was the North Atlantic right whale. And just a little bit about the right whale. The right whale was hunted to near extinction in the Atlantic through the 20th century. And the last couple decades of the 20th century, it was conservation efforts kind of began in earnest for the right whale, and it was listed under the Endangered Species Act. And essentially, the tail end of the 20th century and the beginning of the 21st century, the right whale kind of looked like an Endangered Species Act success story. The population grew in the wild, and it looked like it was on the right road. But beginning about a decade ago, around 2011, the population started to decline again. And it's been in a decline since then, and there's about 350 right whales in the wild in the North Atlantic at this point in time. The other thing I wanted to mention at the outset about the case was that during the course of the consultation, as the focus of the lawsuit, National Marine Fisheries Service applied the precautionary principle, which we'll get into a little bit more, at a number of decision points along the way.
Thanks, Paul. So can you tell us what is the holding of the DC Circuit in MLA versus NMFS?
Yes. As I mentioned, the National Marine Fisheries Service indicated in its biological opinion actually that it was required to apply a precautionary approach or to give the benefit of the doubt to the species in light of the history of the legislative history, of the Endangered Species Act. And the central issue that the DC Circuit took up on appeal was the agency's reliance on this precautionary principle, which, as I already mentioned, has been variously referred to as giving the benefit of the doubt to the species or a presumption in favor of the species. There are some other ways it's referred to by the litigants, but that you get the gist of it. In a two-part holding, the DC Circuit first addressed whether the National Marine Fisheries Service was required to give a presumption to the species, and the court held that as a matter of law, it was not, that the Endangered Species Act and its legislative history did not mandate that the federal wildlife agencies are required to give the benefit of the doubt to the species. The court went on in the second part of its holding to look at whether it was essentially appropriate to exercise discretion by using a presumption in favor of the species. And on that count too, the court held that it was inappropriate for the National Marine Fisheries Service to do so. what the court essentially held was that giving a presumption in favor of the species was inconsistent with the requirement to use the best scientific and commercial data available, which is also a requirement in Section 7 of the Act that's explicit there. And the court went on to note that it has a potential that a presumption like this has the potential to distort decision making.
Thanks, Paul. So can you tell us a little bit more about what the precautionary principle is?
Yes. So it's been described in a number of different ways over time, but there's a couple of shorthand ways the precautionary principle has been described. One that I kind of like actually is analogizing it to the Hippocratic Oath, which is first do no harm, right? Another shorthand that I've seen in the literature is better safe than sorry. And this, in the context of concern about human impacts on the natural world, is obviously kind of intuitively appealing to many folks. The principle actually was developed really in the context of a proliferation of our use of chemicals over time as a society, which have many societal benefits, but also have the potential to harm both human health and the environment. And so when you look at like its its development over time, it has been kind of a central focus of debates about whether to regulate or ban or phase out lots of different chemicals ranging from DDT to PCBs to CFCs, and now we're talking about PFAS, and it's the same kind of scenario. But in practice, its application can pose problems, including in the areas of environmental policy outside of exposure to chemicals. And so that was the focus of the decision in the case here. That said, the precautionary principle has been relied on by the Fish and Wildlife Service and National Marine Fisheries Service in a variety of ways. And I provide just a couple examples on this slide in shorthand. One would be assuming an action is harmful to a species, absent of showing it is not, or assuming it's harmful in the face of uncertainty. And a similar would be assuming that a species is at risk of extinction, and therefore, for example, should be listed absent of showing it is not, or in the face of uncertainty.
With that said, what are some ways that the precautionary principle has influenced the NMFS analysis?
So in the context of the right whale litigation, a principal way in which it influenced the National Marine Fisheries Service was the agency used quantitative models for two purposes, really. One was to predict the effects of the fishery on the right whale, that is the lobster fishery. And another is to project right whale population trends over time. And when it was doing that, it was a multivariate analysis that considered the fishery, but also all sorts of other effects on the right whale population. When the agency did so, the precautionary principle apparently, based on the record, influenced, for example, its choice of data sets used in the models, its evaluation of patterns of distribution of the species, and its assessment of the efficacy of different conservation measures that could be taken or were being taken in order to contribute to the protection of the right whale over time. And the boxed language is taken from the National Marine Fisheries Service biological opinion, and I wanted to just draw folks' attention to the last two lines, because this was a focus in the litigation and a language that the court took note of. So here, the agency said, we utilized metrics representing the worst case scenario, and this is in the context of modeling. And then they said, consequently, model outputs very likely overestimate the likelihood of a declining population. In my experience, a precautionary approach like this is actually not uncommon for the wildlife agencies to take, as NMFS did in this circumstance. This case may be a little unusual because of the extent to which NMFS, as in this quote, actually was forthright and very clear about its decision-making process and the role of, here they call it the worst case scenario, or using a presumption in favor of the species.
So what are some risks associated with reflexive use of the precautionary approach?
The one risk that the court was focused on and the litigants is the potential that a precautionary approach can have societal consequences, even while the benefits of taking action may be speculative or may be uncertain. And so that was a risk that the court focused on. But there was another risk identified by the court, and that was the potential for a precautionary action to potentially benefit one species while harming another. A similar type of risk that I've seen is the potential for precautionary action to benefit one life stage of a species while it may harm another. And a classic kind of example I've seen of that out here in the Western United States is when we're talking about water management in a very resource-limited circumstance for example, steelhead. It may be that upstream releases provide benefits to one stage of a species, but could result in dryback later in the season that could have detrimental consequences for another stage. And so there is a need on the part of the agencies and others to evaluate the extent to which that kind of a precautionary action could have consequences outside of the particular focus of the agency's analysis or assessment. The other thing I think is worth mentioning here is that needless to say, there's a reality that as a society, we don't have limitless resources for conservation. And so the more we expend on precautionary actions that may be speculative or uncertain, the less we may have to expend on other actions that either may be more certain in their benefits or may provide greater benefits. And so there's a balancing that may not occur if the focus is on a precautionary approach and it's narrow in its emphasis. And this could be with regard to, a life stage of a species, like I said, but also with regard to evaluating effects on other species or effects on human society.
Can you explain this map a bit?
Yeah, sure. Yeah. So this is another kind of aspect of the precautionary approach that I thought was worth mentioning, which is this building on the idea of misallocation of risk and the potential for misallocation of conservation benefit. And I want to say just at the outset, this graphic is just intended to help me make this point. I'm not going to argue about the relative risk of any particular human activities identified in the graphic, just using it to make a point about risk and precaution. What I will say is that right whales can face a number of potential risks on the eastern seaboard, and the ones I've identified here are ones that you see in the literature or in the popular press, frankly. So some of those risks can involve entanglement in fishing gear in different fisheries along the eastern seaboard. They can involve vessel strikes by vessels of different size in different geographic areas where the species migrates. They can involve use of sonar by the Navy. That's an area that's been studied in the past. And then more recently, there's been some concern about offshore wind development, which is still largely hypothetical, but seems to be coming to fruition, and the potential for it to have impacts both during construction and operations. When we do develop quantitative models to estimate the relative impact of these different stressors, if, for example, we make an assumption that one contributes a greater risk to the species, then the model outputs are likely to understate the remaining the risk associated with the remaining stressors. So, for example, if NMFS is looking at offshore wind and they kind of put a thumb on the scale in terms of being conservative in their approach and overemphasize the effects of offshore wind on right whale in light of uncertainty, that may lead them to underestimate the impacts or the risk of other activity, for example, Navy sonar or vessel strikes, and therefore under-regulate in those areas. And so for this reason, particularly in the modeling context, when we're putting a thumb on the scale in one direction or another, there's a potential for that to have implications that in terms of the actual conservation outcomes of the species, because we could be expending effort on essentially misguided conservation efforts that aren't going at the highest risk to the species. I will note in this context from the literature that actually comes from the agricultural economics literature, there's a concept of a limiting factor. And that is the idea that there may be one factor that is contributing to limiting resource availability in a particular area. And this can apply in the context of endangered species management as well, where if for example, a species is food limited, we could be taking all sorts of efforts to ameliorate other factors or stresses on the species. But as long as it's food limited, we may not see a population response. And that's the same concept here if you're misallocating risk.
Now that we understand a little bit more about the risk and those sorts of things, what did the court say about the precautionary principle and reasonably certain to occur?
So Amanda will talk about reasonably certain to occur in greater detail. But that term appears in the pre-Trump consultation regulations, in the Trump consultation regulations, and in the Biden proposed consultation regulations. So the term reasonably certain to occur is likely to continue to occur in those regulations. And the DC Circuit, one of the areas where they identified a tension in the National Marine Fisheries Service approach with the precautionary approach actually had to do with the reasonably certain to occur language in the regulations. And this quote is from the DC Circuit's decision, where the agency finds a tension between a precautionary approach and using a reasonably certain to occur standard. In some sense, I think this is kind of an analog to the tension between a precautionary approach and a risk-based standard, such as the standard I was describing when I was talking about the previous slide.
Thanks, Paul. That's a really great recap on the Maine Lobstermen's Association case. So now with that, we're going to pass it over to Amanda Glenn. She's going to talk more about the regulatory updates and that term reasonable certainty that Paul had just mentioned.
All right. Well, hi, everybody. I'm Amanda Glenn. I'm here to talk about regulatory updates, which is one of my most favorite things. And 2023 has not disappointed. It's been a very busy year. There are a couple of things in particular that we're going to talk about today that relate nicely to the Lobstermen's case that Paul just talked about. The first involves a series of proposed changes to the Section 7 interagency consultation rules. So that's the part of the act that addresses how activities that have a federal nexus get authorization under the Endangered Species Act. That proposed rulemaking, which came out, I think, at the end of June, just a couple months ago, did a couple of interesting things. The first, which is maybe a little bit more nuanced, but again relates directly to what Paul was talking about, is that it revises somewhat the guidance that's contained in the regulatory language itself about what reasonable certainty means and how it's applied to the definition of effects of the action, which is basically the thing that sets the entire scope of an analysis to get through that Section 7 process. So kind of a fundamental concept. The second thing that this proposed rulemaking does is that it introduces the concept of compensatory mitigation into the Section 7 process. This is a pretty bold move by the services. For decades prior, the agencies have taken the position that compensatory mitigation isn't a standard that's applicable to Section 7 consultations. The conservation standard was in actuality, you had to avoid and minimize the amount of impact, but not to compensate for it. So this proposed rulemaking takes a pretty bold step and says, nope, we're going to change direction on this, and we are going to give the agencies the ability to assign an obligation for providing compensatory mitigation to fully offset the impacts of incidental take that is reasonably certain to occur. There's that word again, in a Section 7 consultation. that's pretty big news. The second thing that happened that's kind of related to all of this stuff involves performance standards for what compensatory mitigation under the Endangered Species Act actually is. In May, the Fish and Wildlife Service published a final policy, not a rule, but a policy that articulated a series of performance standards for compensatory mitigation that included, amongst a long list of things like standards for durability, standards for accountability, standards for siting, standards for collaboration when you are developing compensatory mitigation measures. A whole long list of things. These are fairly new, at least articulated as policy. So that came out in May. Both of those, right, say like that package, all kind of relates to these concepts of reasonable certainty and relate to that tension that Paul was talking about the precautionary principle on one side, giving the benefit of the doubt to the species, versus the standard of reasonable certainty. So, kind of begs the question, what does reasonable certainty actually mean in this context? And, it's not well defined in the Act at this point. There is no definition for what reasonable certainty means. So if we think about it in kind of a layperson's terms, I might articulate reasonable certainty as being pretty darn sure that something's going to happen. You can also think about it in terms of a kind of a qualitative spectrum or of likelihood, where you have something that's impossible on one side of the spectrum and something that's definitely going to happen on the other. Where does reasonable certainty fit? All things being equal, what side of the fence does that term fall on? I would argue that it probably falls on something being more definite or more likely than not to happen. So I'd kind of put it over there. But, as I said, it's not a term or a phrase that's actually defined. It's actually not even used at all in the text of the Endangered Species Act. But it does appear in the implementing regulations established by the agencies for working through the Endangered Species Act. It appears in the definition of effects of the action. It appears in the definition of what constitutes a cumulative effect. And it's used as a regulatory threshold for understanding when those effects rise to the level of incidental take and how much take should be authorized in connection with a certain action. It's also discussed at some length in policy and guidance documents. There's a lot of discussion about reasonable certainty that appears in the preamble notes or the front end matter when the agencies publish a proposed rulemaking in the Federal Register. All of that discussion is like providing policy or guidance. There's a lot of discussion there. And it also appears in things like the 2016 HCP or Habitat Conservation Planning Handbook and some other guidance memoranda. So why does reasonable certainty matter? Like, why are we talking about this term that seems to be poorly defined and not very clearly applied? And I think the importance of reasonable certainty is that decisions under the Endangered Species Act are supposed to be made on the basis of the best available science, but not even the best science often provides sufficient information on which to make a decision. There is always uncertainty in science. Science is a process. It's not a particular state in time. And so we're always dealing with uncertainty when we look at and apply science to decisions. And so there's a lot of professional judgment that goes into understanding what science is appropriate to apply to a problem and how to navigate or address the uncertainty that's kind of inherent to that body of knowledge. And so that kind of reasonable certainty as a standard of professional judgment really does have a big influence on the substantive outcomes of a lot of Endangered Species Act related analyses. What are the effects of an action that you have to consider in a consultation process? How much take do you need take authorization for an action? And kind of the follow-on question to that is, how much mitigation is needed to fully offset? What does fully offset even mean in that circumstance? So professional judgment bounded by reasonable certainty is kind of the basis for making a lot of really influential real-world decisions. So given that reasonable certainty is kind of an important concept to implementation of the Endangered Species Act, we've actually seen a lot of flexibility, or it's been a circuitous path to understanding what that term reasonable certainty means and how it's applied. And I would say that over the last decades, if not longer, there's been kind of a ping-ponging of opinion about like how certain, how likely is reasonably certain actually, does that actually need to be before you can make a decision? You can see some of the influential things that have happened in the last 20 years or so, but we're kind of left at an interesting position here today in 2023, where we've got the Lobstermen's opinion on one hand that says, you know, the precautionary principle really isn't a solid basis for making regulatory decisions under the Endangered Species Act, versus the proposed rulemaking for the Section 7 process that kind of throws a little bit of shade on the strength of that reasonably certain to occur standard that came out in the 2019 package of Section 7 updates that Paul talked about. So we've got two things happening right now that kind of are pulling in opposite directions. And so it's going to be interesting to see how that settles out, because I don't think we do have clarity yet on what reasonably certain actually means, how it's applied, and how we all think about it. And I think that, you know, that tension, that lack of clarity is getting to be ever more important. So as I kind of mentioned before, the current proposed rulemaking for the Section 7 process would weaken in somewhat subtle ways, but I think ways that are real, language that was fairly clear about the strength of that reasonably certain to occur standard. And when that reasonably certain to occur standard isn't quite so clear, it really does complicate decisions about the basic scope of an analysis under Section 7 or even Section 10. And if you can't get clarity or consensus about how to start the process of analysis, it's really tough to get all the way through that process of analysis to an actual decision and an authorization that lets your project move forward. So it's really pretty consequential that some of that clarifying language that first appeared in that 2019 rulemaking is now kind of being walked back just a little bit. It opens the door to more confusion and I think lack of clarity about what that standard means and how it's applied. It also kind of begs the question then, who, if anyone, is responsible for effects that are just like maybe not meeting that reasonably certain standard, but are effects that might occur or things that could happen. We see a lot of analyses or findings in things like biological opinions about, you know, this effect might occur and therefore we're going to do X, Y, and Z about it. Is that a sufficient basis for making those kinds of decisions? Who's responsible then for mitigating that if mitigation actually becomes part of that Section 7 process? And then we've got that, the addition of mitigation to the Section 7 process, coupled with that new policy that, makes mitigation a very high standard. I think that mitigation policy, while it is most certainly going to make mitigation better, higher quality, more durable, more effective, all very good things. But I think at the same time, it also makes those opportunities for finding things that even qualify as mitigation a little bit more scarce. And scarcity brings up cost. It'll probably make them more expensive. So things that might qualify for compensatory mitigation are probably going to be less easy to find and more costly when you do find them, which again has kind of implications for how people think about going through the process of compliance and the kind of amount or level of effect that they're willing to take responsibility for. So where do we go from here? Kind of in light of these proposed rulemakings, the mitigation policy, my crystal ball suggests that we can probably all expect additional clarifications, either by agency rulemaking or court opinions, or probably all of the above, as we all dial in on consensus for what reasonable certainty means and how it gets applied. I think we can expect there to be a bigger incentive to get that reasonably certain to occur standard right when we are talking about impact analyses. So identifying things that are effects of the action and generate an obligation to then mitigate. So, I think that, if you're not already doing this, making sure that when you are going through these processes, that you are clearly documenting rationale that supports kind of applications of that reasonable certainty standard to each kind of logical chain in your analysis process. That's going to be how you kind of get a little bit of certainty for moving through this process, and consistency and a little bit of predictability, to the extent that those things are even possible. Oh, and I think that's it. Let's take some questions.
Yeah, thanks, Amanda. That was really good. I especially enjoyed the last comment there on what you all can do. Document, gather the information you can gather. I think that's one of the biggest points of this whole thing. So as a reminder, we do have a Q&A available. You can click on it and put your questions in there. We do have a couple initial questions that we can go ahead and start to answer. The first one being for Paul: what is the status of the Lobstermen's case right now?
Mute here. So the case was decided in mid-June, and the government actually has, and the environmental groups that are appellees in the case, they have until mid-September to decide whether to seek Supreme Court review. So until then, the case is still live. The Court of Appeals hasn't issued what's called a mandate. I don't anticipate that they will do that, but I'll breathe a sigh of relief in mid-September if they don't. And at that point, then the case will be kind of settled law if they do not pursue it further in the DC Circuit. So that means that for other cases that come up in the Court of Appeals in DC, the case will be precedent. But many other cases come up in other parts of the country. And so in other courts of appeals from other parts of the country, the case may be persuasive, but won't necessarily be binding. And so the kind of overall implications of the case still remain to be seen, I think.
Thanks, Paul. Another question is there a timeline for the proposed rule to be finalized? And Amanda, I'm going to pass this one to you.
Oh, I have not seen a timeline published for finalizing that Section 7 rule. It just came out at the end of June. The public comment period closed, I think, August 21st. They received like more than 100,000 comments, I think, on regulations.gov. It may take them a hot second to like process all of those comments and consider if any changes to that proposed rule are warranted. So
we'll see.
That might take some time. Yeah, but at the same time, we are coming up on an election season, and those kinds of things have consequences for agency decision making. And so I suspect that they will try to get it done as soon as possible in front of that, a possible change in administration, when who knows what might happen. So the short answer is no. The long answer is probably sooner rather than later.
So Thank you. Another question is, when in an uncertain situation, are there other data that can be used? So maybe if you don't have enough data at your fingertips, or scientifically peer-reviewed data, things like that, is there other data that can be accepted and used in certain circumstances? And Paul, I'll swing that to you first, but Amanda, feel free to chime in.
So there's a variety of sources that could be used. Some of them are other data. So for example, it's not uncommon to use data on surrogates. Sometimes we'll have like a habitat surrogate for a species that's hard to find. Sometimes we'll use one surrogate for a similar species. So for example, out here in California, oftentimes, particularly for studies, we use hatchery Chinook salmon to do studies that we then use to project effects on wild Chinook salmon or even wild steelhead at times. So there are data like that can be used. Oftentimes, when that's the case, there are kind of best practices associated with that, because obviously there's a risk when you do something like that, that it could be non-representative. For example, whenever using one surrogate as a species for another, in some ways, the more they overlap, but they're distinct, that suggests that they are occupying unique ecological niches, even in the same geographic area. And so it could be a little risky to say, oh, well, we've got two lizards here in the same space, they must act in the same way. If they acted in exactly the same way, they wouldn't be two different lizards, right? So the scientists know a lot more about that than me, but I know enough to know that much. So anyway, Amanda may have more to say about this, though.
I like that. I like that answer, Paul.
Thanks, you too. One more question, and as we're doing questions, just a reminder that if you do have questions, we see a few coming through the Q&A. We will get to those in just a minute, but feel free to throw your questions into the Q&A as we're answering some of these others. So another question, kind of the flip side of that, is, are there any data that won't be used by agencies? And maybe this is not a finite answer, but thoughts on that topic. And Amanda, I'll pass it to you first. And again, same thing, Paul, if you want to jump in.
Well, the agencies are directed to make decisions using the best available science. And we can kind of pick apart, what that means. Is the science available? I guess if something's not available, you can't use it. Is it best? Is it suitable for answering the question? Is it reliable? And I think, Paul, there's Information Quality Act that also kind of relates to helping to understand what best available science means. And so, but again, those are judgment calls too, right? Is a piece of science issued in a public or a peer-reviewed journal necessarily free of error? Is it definitive itself? Maybe not. Maybe it's not the best data to use in a particular circumstance. That's a really complicated question. And I think, the provenance does matter. Something that appears in a peer-reviewed journal is probably going to be given more weight, be more science-y than, let's say, perhaps, community generated or citizen science kinds of things, or incidental observations kinds of things that might be posted on eBird or iNaturalist or, sources like that. But it's a judgment call.
Yeah, I would say, there is some guidance from the Office of Management and Budget on the Information Quality Act, and from the agencies, because each of them has developed their own Information Quality Act guidelines. And that does have the kinds of considerations that Amanda was referencing, like peer review, other forms of kind of validation, even the citizen science like iNaturalist or eBird or what have you. They themselves have started to develop, their own kind of quality control, and I'm not super familiar with those, but I know enough to know that. So I think that those data can be relied on, but the agencies will look at it on a case-by-case basis. And then the other thing is that there can be changes, right? So we can have data that is outdated, for example, because of changes in the environment, or out here, for example, we saw in the San Francisco Bay Delta, there was a big regime change because of a change in the food web due to an invasive species. And so if you look at data from pre and post that regime change, there's lots of different information about other species that were affected by that. And so, the agencies need to exercise judgment in doing this. At the same time, I think that there are prevailing scientific practices, kind of best practices in how to do these things. Even, with regard to peer review, for example, there are good peer review practices and poor peer review practices. And so that's kind of, to me, that's part of so than professional judgment, that's part of the overall best available science kind of concept. Even though the Act refers to the data itself, there are well-established practices in the sciences that also can inform how we utilize those data.
Awesome. Thanks, you too. And I will add that I've been impressed with some of the reviewers that have gone into things like eBird and whatnot, who are some experts in those species that do go in and review data. However, community science is also collected in various ways. So it just depends on the portal and the instructions and methods that are used. So we are going to jump to a couple of these Q&A questions. The first one, I have to warn you all, is a little bit long. We're going to have to suss it out a bit. But what it says is, along the lines of finite mitigation opportunities, do you think requiring mitigation as part of Section 7 consultations pits these projects against Section 10 permittees and programmatic habitat conservation plans for competition, for mitigation, for species with narrow ranges? So I know that's kind of a loaded question. So I think it would also be good for the audience to understand, again, Section 10 versus Section 7. Again, Section 7 has a federal nexus, and Section 10 is the non-federal entities that are receiving or going through habitat conservation plans for their take coverage. So, and then there's a second part to this question, but let's think about the first part of the question about Section 10 consultations, pitting these projects against Section 10 permittees and programmatic habitat conservation plans for species with narrow ranges, if you understand that question.
I think the answer to that is yes. I mean, you're increasing the pool of projects or activities that are going to be chasing the same kinds of mitigation solutions or opportunities on the landscape. If those opportunities are already limited and constrained because maybe it's a very rare species, there's just not much known about it, there's not a lot of good established mitigation options that now also have to meet those new performance standards, then yeah, at least there's a potential for at least a short-term kind of conflict, rush to the finish, maybe. So yeah, more demand, less supply.
The other reason that this is the point is important is because, and this is one of the areas of contention that the wildlife agencies are undoubtedly going to have to respond to. Section 10 specifically requires that the take be minimized and mitigated. Section 7 only refers to minimization. So historically, that requirement for mitigation, it isn't in the ESA and it hasn't been there. And so when the wildlife agencies are trying to extend the mitigation requirement into Section 7, that isn't in the Act. And so it does mean that there will be likely, as Amanda suggested, additional kind of pressure on the system to make mitigation available. But at the same time, I will say, as an informal matter, it's not infrequent for folks that are involved in Section 7 consultation to essentially, when they're developing their proposed action, to include mitigation in their proposed action, to kind of build it into their action in order to reduce the overall effects to the species. And this may be just because they want to avoid jeopardy, which is required under Section 7, or it may be because it will make the consultation process work a little more smoothly. And so there already is some demand under Section 7 for mitigation because of the practices of the regulated community in seeking it out. But I do think it will increase with that requirement.
Great. I'm going to actually have us go back a little bit because there's a question related to what we were just talking about in terms of data that can be used. So the question on this one is, do you suggest a way for developers to submit monitoring data for scientists to utilize as a database to make these decisions without being potentially penalized? I think the question is about data. What data can be used? And Amanda, what do you think?
Yeah, I guess I would start by talk to your attorney. I think that it depends on the context. Obviously, if you've got so there's different aspects of this. One, usually if you're collecting data on listed species, usually you're using a consultant who's got a 10A1A permit. They've already got reporting obligations, so those may be delineated in the permit, right? And the consultant may already be aware of what they're supposed to do and why. Typically, my experience with consultants is they are well aware of that because that's the permit requirement for them, and that is a mandatory permit requirement. So, but in terms of being affirmative about it, there is some tension between disclosing information that could make use of your property, for example, more difficult, and working with the agencies, but particularly if you need agency authorization or you have the potential to take activity that could result in take. You find yourself having to work with the wildlife agencies anyway. In those circumstances, I think you'd work with kind of your permitting team to figure out how to disclose what information you can. I would say as a broader matter, one of the challenges for the agencies is they don't have all that information. So, when they're looking at distributional data on any listed species, they've got what they've got access to. And so in some areas, for example, areas where you've got a lot of private land, they may find it a lot more difficult to understand the distribution of species, how abundant it is, what kind of trends there are without that information.
Thank you. We have time for about one or two more questions. And as mentioned earlier, we will follow up on some of these other questions over here. One question that's more broad is, can the agencies retroactively apply new listings, standards, et cetera, to previously approved projects or projects that are already under construction? So I think that's maybe a more general consultation question if you have a new species that's listed and your project is underway.
Yeah, I think it depends on the new information that happens. So, for instance, if this new Section 7 regulation gets finalized as proposed, the regulation, at least as proposed, says it would not apply retroactively. So if you have gone through a process of consultation, you have a biological opinion and a take statement, and none of that includes mitigation, you should be fine to rely on the process that you've gone through, even though going forward, if you were to do it again, it might come out a little bit differently. So a lot of those kinds of regulatory changes don't apply retroactively. Now, new listings are another matter entirely, because if you have a new listing, it is a reinitiation trigger for that Section 7 consultation, which if you enter into reinitiation, that's a new consideration, and now the new regulations will apply. And also, you wouldn't have take authorization for that newly listed species if it's needed. And so you might have to go back to the agency to get some new authorization.
Well, and I'll just add that that can be even complicated. Let's say you got your, you did a consultation because of a Corps of Engineers, like wetland fill on project site, and you're building out whatever it is, a house or a wind turbine or what have you. Once you've completed construction and filled the wetland, the Corps no longer has any interest in the site. And so they don't have ongoing obligations. So if there's a new listing on your project, even after you're up and running, you still got to figure out, do you need take authorization? And if so, you may need to find a way to get it or to avoid take other than through that prior Section 7 consultation.
Yeah, one thing that it also makes me think of is, best available science is still used by the agencies. And so what I've seen happen on some projects is you have one project and you're working with the agency and more information is coming out, more science is coming out, and it's directing your mitigation or even your minimization efforts to be a little bit different from consultation to consultation. And that can frustrate companies. However, you do have to be aware that they are trying to use the best available science. It might make them happy, it might make them sad, depending on which way it turns out. But that is, as science comes out, that new information is being utilized. We've hit the 1 o'clock hour. I'm going to ask one last question, and I'm going to give this one to Paul, and then we're going to wrap up. So the last question is, the decisions of the DC Circuit in the Maine lobster case regarding protecting one species at the detriment of another seems to potentially apply to the northern spotted owl and the Pacific Northwest logging industry. And Paul, you can answer this however you'd like. Your thoughts on potential future litigation in this regard? ?
So the DC Circuit made a passing comment about, the trade-off between protections on different species. The decision didn't really address that. So that's not part of the holding. To the extent that they did that, we call that, lawyers call that dicta. It's not kind of binding precedent in any way. I will say more broadly, though, that we can expect to see continuing litigation in lots of areas. And the spotted owl, is one where it's certainly been a hot button in the past. And so with regard to that and other species that, are species that are kind of charismatic megafauna like that, even though it's not too big, you're likely to see more litigation going forward.
Awesome. Thanks, Paul. Well, I want to take the moment to say thank you to both of you for all of the information that you've provided today. Again, everyone, you should be receiving an email with a link to the presentation and answers to some more questions. So thank you all very much. And we are going to adjourn for this meeting. Thanks.
Thank
Bye.
you.